representation.
If it pleases you, Your Honor. Learned Counsel, Madam Kiso. Madam Kiso and Madam Kiumba appear for the state. Mr. Callisto has put his name on record for the accused persons. We've contested his appearance. Mr. Wanjir, Mr. Abuya, and Kikoech appear for the various interested parties and victims under the Victim Protection Act. If it pleases you, we are more than ready to take the ruling.
Very well, this is the ruling. Early this afternoon, 6 persons were brought before me. Where are they? You all present. Francis Washira? Alexander?
Yes, sir.
Isaac Ochieng?
Yes, sir.
Isaac Ochieng.
Yes, sir.
You see, you are masked. I only get to hear the sound.
Yes.
Isaac Ochieng,
Yes, sir.
Michael. Michael?
Yes, sir.
Yes, come next. Evans Tumayo?
Yes, sir.
Yes, come next. Then Abdul Rahman.
Yes, sir.
Ali Sodi. Yes, early this afternoon, 6 persons were brought before me to take plea. They are Francis Washira Gashoki, Alexander Lorogoi, Isaac Ochieng Odhiambo, Michael Abukala, Evans Kimayo, and Abdul Rahman Ali Sudi. Before plea was taken, an issue was raised by Mr. Abuya, Mr. Kikoech, and Mr. Wanjir, appearing as watching brief for the complainants, the Law Society of Kenya, Vocal Africa, and IMLU. The issue revolved on Mr. Leon Callisto's representation of the person's child. They jointly pointed out that Mr. Leon Callisto is the legal officer employed by the Kenya Wildlife Services, which I'll be describing as KWS for purpose of this ruling. They submitted that the said counsel cannot represent the accused person on the following grounds. 1, that criminal culpability attaches in persona, hence not institutional. That the offense is against the accused persons and not KWS. 2, that Mr. Callisto is conflicted by dint of drawing salary from the government, hence cannot represent individuals at trial. 3, that Mr. Callisto can only represent the accused person if the offense was sanctioned by KWS. 4, that the case has nothing to do with KWS as an institution, but against the 6 individuals. And finally, that allowing Mr. Callisto to represent the accused persons would reduced the case to ODPP versus KWS. Mr. Callisto submitted in response that the accused persons are officers of KWS and that being the institutional lawyer has a duty to represent the accused person. He submitted further that he holds a valid practicing certificate. He stated further that the alleged offense was committed while the persons charged were discharging their duties as officers of KWS, hence KWS has the institutional responsibility of representing the accused persons. He stated that this is not an isolated case as he represents the institution in other similar cases. He submitted that the institution did not see the need to outsource legal services for the accused, hence opted to utilize the internal lawyers and for this case himself. Article 52G and H, to which the application subject of this ruling dangles, provides as follows. Every accused person has a right to a fair trial, which includes the right, G, to choose and be represented by an advocate and be informed of this right promptly. H, to have an advocate assigned to the accused person by the state and at state expense if substantial injustice would otherwise result, and to be informed of this right promptly. All submissions presented both for and against are in agreement with this constitutional provision as outlined above. The departure, however, in this case is representation by Mr. Callisto, the legal officer of KWS. To put things straight is that it is not in doubt that Mr. Callisto is an advocate of the High Court of Kenya and also a valid practicing certificate and qualified to practice before this court. According to Mr. Callisto, and also not in contest, is that for purpose of this case, he draws his instruction from KWS, who doubles up as the employer of the accused persons in this case. The counsel's watching brief holds the view that criminal culpability attaches individually. Therefore, the institution, and in this case KWS, has no business seconding a counsel to represent the accused persons. For clarity of record, the prosecution opted to stay away from the present contents, hence did not make any submissions. I agree with the counsel's watching brief that criminal culpability attaches in persona. The person sued or charged bears individual responsibility of crime and is sanctioned or punished in person. KWS, as submitted by Mr. Callisto, held the view that since the offense was alleged to have been committed by the accused persons in the course of executing their duties, then they have a duty to defend them by seconding their counsel. The relationship between the individuals charged and KWS as an institution is not in doubt. From the submissions of Mr. Callisto, KWS does not seem to believe in the charges, hence instructed their counsel rather than outsourcing. I do not, with respect, see anything wrong with this arrangement. Even assuming that the accused are found culpable in the end and a recourse is pursued by the complainant, the recourse would, by dint of the relationship established, lie on the institution. Hence, they have a right to protect their institutional interest from the four. My other question then would be, will Mr. Callisto's representation of the accused in any way occasion prejudice? None has been submitted before me. Nothing has been laid before me demonstrative of any prejudice. As I conclude, an issue was raised that Mr. Callisto is conflicted to the extent that he draws his salary by representing accused person in their individual capacity. This position takes me to the middle of this ruling on the interest of KWS in this case. Other than defending the individuals who are employees of KWS, KWS is protecting its institutional interest. I do not, in the premise, deduce any conflict. The Constitution, as pointed out and as lifted above, only makes reference to right to representation by an advocate. It goes further to state that an accused may be represented by an advocate at the state's expense. There therefore lies no conflict. In the end, I do find that Mr. Callisto is within his right in representing the accused persons herein. He is permitted as such. Those are the orders of this court.
We are very much obliged, Your Honor. We are now ready to take plea on behalf of the victims and the complainants.
Yes. Which language? Read out.
Your Honor, as part of housekeeping, and we do not intend to get into the nerves of the court, this is a very special occasion. And we were told, and I think this is the practice in Commonwealth, that court appearance is more than a ceremony. Your Honor, would you be able to give guidance to the accused persons that they should not be seen to be like they are masked deliberately to hide their identity? Because it can be by coincidence that all of them have viral or fungal diseases. Could there be some neatness in the way the accused persons appear? They are officers of KWS. What is the problem in unmasking? We also want to see them. This is a public court. These are open proceedings. What are they hiding?
Your Honor, I don't see any prejudice to my clients having their masks on. Court has in recent and past times proceeded with accused persons.
I do not wish to even make a determination. Just remove your mask.
Very well.
Let us stop that.
Very well, Your
For purpose of this court, I do not entertain cheering or even clapping. Yes? Let's keep the silence as required. Yes, read the charge. Which language? Just Francis, which language?
Alexander?
Sorry.
Isa? Mshtakiwa na kosa ya kuteka nyara kwa nia ya kufungulia kinyume cha sheria kwamba tarehe 18 mwezi wa Januari mwaka huu mwezi wa 5 katika Kondeni area na Kìlling Sub-County na Kìlling County kwa pamoja na wengine ambao hawakuweza kufikishwa hapa kotini. Mliteka nyara Brian Odhiambo mkiwa na nia na kwa ubaya kumfungia mahali pasipojulikana. Ni kweli ama si kweli? Francis?
Si kweli.
Alexander?
Si kweli.
Isaac?
Si kweli.
Michael?
Si kweli.
Evans? Abdulrahman?
Si kweli.
Yes, plea of not guilty recorded for all the accused persons. Yes, Mr. Kalisto.
Noting that a plea of not guilty has been entered, I have two applications to make. The first application is my clients are Kenyan citizens, gainfully employed by Kenya Wildlife Service. They are currently on police cash bail and have today presented themselves today before court for purposes of taking a plea. They have a qualified constitutional right to be released on affordable and or reasonable bail and bond terms. And in the circumstances, they are not a flight risk. Your Honor, there is an affidavit have been presented here, sworn on the 5th day of May, 2025, by Elizabeth Auma Ogega. The affidavit is to the effect that in the event my clients are released on cash bail, there is a likelihood of interference with the witnesses. Your Honor, from a cursory perusal of this affidavit, court will note that these are mere averments. They are not substantiated. There is no any tangible, real, actual evidence that has been placed before court to support the averments that my clients will interfere with the witnesses. They have stated in the affidavit that they reported the incident of interference to the DCI. Unfortunately, no OB has been attached to this affidavit to confirm those averments. He who alleges must prove. They have failed to do so. In the circumstances, Your Honor, there are no compelling reasons as provided for in the bond and bail guidelines or section 123A of the Criminal Procedure Code. And in the circumstances, Your Honor, I pray that my clients be granted reasonable bail and or bond terms, they will at all material times, when and as required by court, avail themselves in the circumstances. I pray that a reasonable bail be granted to my clients. That's all.
Prosecution.
Yes. Your Honor, on behalf of the prosecution, with respect to bond, we are praying that bond be suspended at this point for the following reasons. When we were earlier in court today, before we took a break, we were served by Mr. Abuya an affidavit by one Elizabeth Auma, who is the mother to Brian. The affidavit is dated the 5th of May 2025. The affidavit there has raised serious allegations of possible witness interference. Your Honor, the law requires, before bond is given, the law requires that, or denied, the law requires that we demonstrate compelling reasons in oppositions of bond. Your Honor, the allegations of possible witness interference have not been formally reported to the station. The investigating officer has been informed today. No investigations of the averment contained in the affidavit have been undertaken. Considering the averments therein are grave and will touch on whether the accused persons are denied bonds, we propose that the same be subjected to investigations and we be given time for the IO to undertake that. We also propose that a mention date be given during which we shall present our substantive position on the issue of bail or bond. We are also proposing that prebail report, the court calls for a prebail report in the meantime.
Your Honor, I'm not so clear as to whether counsel is opposing the application for bond or is acceding to the same. Another issue, we are way past the issue of representation, and I strongly object to my senior counsel addressing you. The case is now in the hands of the state prosecutor. If they have any issues that they feel they can address to you, they can always channel them.
Have you gone through the Witness Protection Act?
Yes.
You're familiar with the content there?
Yes.
The Witness Protection Act.
Yes, Your Honor.
Yes?
Yes, Your Honor.
that should end your submission.
Very well, very well.
Yes. So, please.
Your Honor, very briefly on behalf of the interested parties that we represent and the victims, on the basis of the affidavit dated 5th of May 2025, deponed to by Madam Elizabeth Auma Ogega. This is the mother to Brian Odhiambo. We oppose bond for the reasons stated therein. Your Honor, I would give Mr. Abuya a few minutes after I'm done to give a brief highlight together with Mr. Wanjiru.
Yes.
In other terminology, Your Honor, we rely on Article 41H of the Constitution of Kenya. 49(1)H of the Constitution of Kenya, which allows all accused persons bond, reasonable terms, where there are no compelling reasons to deny bond. So that, Your Honor, whereas the right to bond is a constitutional right and rightfully submitted to by my learned friend, it is qualified. Your Honor, in perspective, this is a very serious offense. Abduction, this is an allegation as it is at the moment, but it's too serious because it has been investigated. The Director of Public Prosecution under Article 157 is persuaded that an offense has been committed. This is abduction by security apparatus of the country. People who are armed, people granted weapons, arsenals of death for purposes of securing the country. But a person disappears in their hands. And to make it very sad, Your Honor, this person has not been found. The mother is here crying, the wife is here mourning, the family, the community, and all defenders of the rule of law. This is a compelling reason why the suspects, the accused persons herein, should not be released until, at the very least, the mother, the wife, and closer family members have given evidence so that their security, their safety, and the integrity of these proceedings are protected. Your Honor, I would refer you very quickly to two decisions, reported decisions of the High Court and the Supreme Court. Your Honor, in the Supreme Court case of Waitito versus Republic, this is reported in 2021 Kenya Law Reports, electronic. The Supreme Court, given an opportunity to review the decision of the Court of Appeal, Your Honor, to grant, to deny, or to qualify bond terms, at paragraph 77, said the appellant has not demonstrated how the exercise of discretion was not judicious and how the learned judges of the High Court and the Court of Appeal erred in failing to interfere with the exercise of the trial court's discretion. Consequently, we do not find any reason to interfere with the Court of Appeal findings. This is a very studious court. I will not belabor to rehash these findings. What is very relevant, Your Honor, is paragraph 64, where the trial court, like this court, looked at Article 49 1H of the Constitution of Kenya and restricted this constitutional right of the accused persons. This is such a case. You are facing officers from the security apparatus, people well trained, using enormous resources to protect lives and secure a country. But in the long run, a poor citizenry disappears in their hands, to date, within their custody, within a national park. There is every likelihood, Your Honor, that they would interfere with not just the witnesses, but also with the integrity of these proceedings. And this is deponed to by Elizabeth. Your Honor, Kenya, under Article 2.5 of the Constitution, has adopted, and this is a very progressive court, international conventions, international treaties and conventions, so as to become part of the Kenyan law. International Convention on Civil and Political Rights is part of the jus cogens of our law. It prohibits, Your Honor, abduction. Kenya is party to the Rome Statute. Abduction by state security apparatus is an international crime. It's a very serious crime. And that is why we are urging you, Your Honor, to find that this is not an ordinary offense. This is not an offense where the suspect is an ordinary person. These are officers, paramilitary officers, trained superiorly. They get hold of a person, a poor person, who evaporates in their hands. As deponed in the affidavit, so much more could happen to these proceedings, to the witnesses, and we urge you, Your Honor, to find that there is a compelling reason not to release the accused persons on bond until, Your Honor, the witnesses that have been mentioned by Elizabeth have given evidence. I know at this juncture you are not determining the case on the basis of proof beyond any reasonable doubt. Yours is to strike a very delicate balance between a victim who is mourning, waiting for the husband to come home, not sure whether the husband would ever come or not, talking about a case where there are depositions in an affidavit, that there is an attempt to interfere. And I am happy the prosecution says they want to investigate. These are very serious issues, Your Honor. They are not wishy-washy. They should be considered, and a balance is struck for the blow of justice. Finally, Your Honor, I wish to refer you to a High Court decision. This is the Republic versus Danson Mgunya and another, 2010 Kenya Law Reports, electronic. And at the risk of repetition, Your Honor, when you retire to return a verdict, I wish to refer you to page 4 of that decision, where the High Court considered what is constitutional right to bond. And the court, that is Muhammad Ibrahim, as he then was, said, Article 49(1)(h), though a constitutional right, is not absolute. It is not an automatic right, and is listed so many other things that would be considered as compelling reasons, including, Your Honor, including, for example, the nature of the offense before the court, that is at page 5. The probability that the accused person may not surrender himself for trial, the likelihood of accused interfering with witnesses or may suppress any evidence that may incriminate him, the likelihood of further charges being brought against the accused. These are some of the things, and the list has been said to be endless. Your Honor, the issue of interference of witnesses keeps on rearing its ugly head. And this court is not lost on the fact that we are in a situation now where Kenya Wildlife Services, which controls the locus in quo, crime scene, is part and parcel of this proceeding. So much so that it has even deputed an advocate. The likelihood of interference with witnesses, the weight of KWS in this matter is so heavy, and we are not contesting the ruling made by the court, but you can clearly see, Your Honor, that not only is the court dealing with accused persons, but you have an institution funded by taxpayers throwing its weight behind the accused persons against poor women, represented pro bono by the Law Society, and several institution defenders of human rights. Your Honor, ultimately we ask you very amply to consider the serious nature of this offense, which could as well turn out to be a murder case. The accused person's official position and training, and the power imbalance between the accused persons and the victims, and deny them bond. This is a very fair court. This is a temple of justice. Should you be constrained to allow them bond, Your Honor, please detain them until the mother, who is mourning, and the wife, who is now, technically speaking, exposed to widowhood, have given their evidence, so that there is no interference and the integrity of these proceedings are guaranteed. Mr. Abuya would say something on the affidavit, and Mr. Wanchayon respectfully submit.
Your Honor, may I say my learned senior colleague, Mr. Kipkoech, has substantively dealt with our view and our position in opposing the application by counsel to have the accused persons admitted to reasonable bail bond terms. Your Honor, may I just briefly say this, that the reasons, as has been put forth by my colleague and the prosecution, are not just mere reasons. They have a basis. But that to have them properly summarized, we are asking the court to consider the following. To consider the fact that the complainant is still missing. Brian Odhiambo is still missing. And he was last seen with the accused persons, alive. He was with them. His whereabouts remain unknown to date. and this fact is not disputed as it's material to this court's assessment, the seriousness and continuing nature of this matter. Your Honor, then, we ask that the court be guided by the need to preserve the integrity of the ongoing investigations, which investigations we believe are active and very fluid. Suffice it to note that the accused persons are all KWS Rangers. The officers, like my colleague said, are specialized in training, logistical capability, and institutional access. I wouldn't belabor this point, noting that even counsel defending them belongs to that institutional juggernaut. That machinery has been deployed here. They possess a real and heightened risk of not only interfering with the crime scene, they also pose the risk of interfering with witnesses, and Your Honor, that is the basis of the affidavit that I'm glad my colleagues have referred to. You know, the affidavit, without really going to its substance entirely, because it speaks for itself, Elizabeth indicates that she has been approached not a month ago, but 3 weeks ago, by an agent. She has even named the agent a Mr. Hosea. Perhaps counsel would be in a position to let us know whether they have a Mr. Hosea within their ranks. But a Mr. Hosea has been sent to the family to ask them to quote their price so that they can let this matter go. It speaks to the possibility of bribing witnesses, noting that KWS would not rest at anything, but would put at their disposal funds even to interfere with witnesses. Your Honor, that affidavit will be placed before you for consideration, but that I'm glad counsel acknowledges service, DPP acknowledges service. We ask the court to have a look at it, even as it will be rendering its decision in respect to this issue. The other thing Your Honor would want to also notice that counsel, I think it was deliberate or by mistake, did not let us know where the accused persons live. Our position is that their abode is not known. How they will come to court then, or how they will be traced to come to court, remains a mirage. We do not know. We don't even know whether there is any of their relatives here. Counsel has not even told us whether there is anyone who would be willing to stand in surety for them. And that is why we are saying it's necessary that, Your Honor, before you even consider that question, that you have a prebail report before you to ascertain the suitability of these gentlemen, or not so gentlemen, to admission to bail. Insofar as we concerned them, until their abode is known, they are flight risk. Your Honor, we also wish to submit that you consider the gravity of the offense they are charged with. I may risk giving evidence from the bar, but having had a discussion with the IO and our colleagues from the DPP, there could be a possibility, a likelihood of additional or upgraded charges. If anything, that would be a sufficient incentive for the accused persons to evade justice. The risk of absconding is not remote, Your Honor. It's heightened by the nature of the allegations and the current status of the complainant. That status, I would repeat, is that he is still missing since January 18th, 2025. If Your Honor is not persuaded by any of those reasons, then consider that this is a matter of public interest. The accused persons are state officers tasked with enforcing the law. Yet they stand charged with violating it in the most egregious way, abduction. Our view is that their release on bail would severely undermine public confidence in law enforcement and the integrity of the justice system. Our view in that regard is that denying them bail will not be punitive. Instead, it will be protective of due process and is essential to the rule of law in this country. Your Honor, in that regard, therefore, I would ask Mr. Wanjir to have a word or two. But the position of Voco Africa, the position of IMLU, the position of the family is that the six be denied bail. I'm glad that that is the position of the Law Society of Kenya, and that is the position of the DPP. I humbly submit.
Mr. Wanjir?
Then I wish to associate myself with the able submissions of my learned counsels. So that I don't rehash whatever they submitted previously. I will only wish to focus on one ground, being public order. You know, the court will take judicial notice of the fact that since the inception of this matter, there has been public unrest. Which has been publicized both in mainstream and print media. To that end, we submit that releasing the accused persons on bail or bond at this moment will disturb public order and undermine peace and security. Pre-trial detention at this moment is necessary to uphold public order and security. As the court retires to render its ruling on the question of admission to bond, we humbly request the court to take into account that it will be in the interest of the public to have the accused persons detained at the moment. those will mark the end of our submission.
Thank you very much, Mr. Kalisto.
Just as a rejoinder to what my learned colleagues submitted, we want to start from the issue of public order. Your Honor, I will refer you to the case of Republic versus Muna Harrison, Ismail and 4 others. High Court Criminal Division number 51 of 2009. And in that case, the court stated that whether or not to grant a bail, the basic factor of the nominal is to secure the attendance of the accused person to answer to charges leveled against them. And one paramount consideration is whether the release of the accused person will endanger the public security, safety, and overall interest of the wider public. As I had earlier submitted, there is no any tangible evidence that has been put forward to confirm that indeed the alleged Hosea, of whom we are not aware of, interacted with the witness. Well, if the alleged Hosea interacted with the witness, why didn't the witness report the incident to the DCI or the police for that matter? And if there is such a report, where is the OB number to that respect? In the circumstances, Your Honor, it is my submission that releasing the accused persons on bail will not in any way or has not been demonstrated or proved in any way to interfere with the public order and security. I also refer you to the case of Ahmed Mohammed. It's Ahmed Mohammed, Republic versus Ahmed Mohammed, where the court stated that the accused persons have a right to enjoy their freedom and in determining whether or not public order or security will be compromised, the court laid down 4 thresholds. Number 1, whether the release of the accused persons will endanger the safety of the public or any person. 2, whether their release may lead to an attempt to evade trial or court. 3, whether their release.
Yoda, kindly, just a moment, Counsel. Can
I am responding to the issue of public
We
security.
have fresh submissions, very fresh. We're wondering whether we will have an opportunity to respond because our time has actually, we do not have that.
This is just a reference to a case.
Exactly.
Good.
I'm referring to a case.
Just a moment. Perhaps I make myself understood to the court. We appreciate his supplying us with the case law and all that. The challenge we would have is that he's adding more that we would have wanted to respond to. We appreciate your rebuttal, but that limit yourself to what we actually submitted on, so that we also don't feel the urge to want to respond. That's all I'm saying, Your
Honor.
Yes, Mr. Kalisto. This is in response to that public order.
Exactly, and
it's
I'm
in reference
quoting
to a case.
An authority to support my submission.
And I'll read the authority, just point out
very
these
well
issues. Yes.
In such a circumstance,
You're in threshold number 3?
Yes.
Whether the release or?
Whether their release will intimidate the witness, conceal or destroy any evidence. And the last threshold is whether their release will undermine or jeopardize the objectives of the proper functioning of the criminal justice system. Your Honor, going by those 4 thresholds, the prosecution has not demonstrated with precision any form of interference or any form or any ground of public disorder. There was also submissions by learned counsel that the alleged individual who disappeared in the hands of KWS. Your Honor, the least to say, that is condemning my clients guilty of an offense they are yet to be tried, contrary to the provisions of Article 49, 1H of the Constitution of Kenya. The issue as to whether or not the alleged individual disappeared in the hands of KWS is an issue that shall be heard and determined by this honorable court and make a determination on the same. That cannot be a ground of denying my client's bail. With those few remarks, Your Honor, I rest my case and wait for your ruling.
To together with the submissions tendered. And I'll give a substantive ruling on that on the 12th of May 2025 at 2:30 p.m. In the meantime, I direct that the defense be supplied with witness statements and all documentary exhibits to be relied on by the prosecution. In the interim, the accused person shall be remanded at Nakuru GK prison.
We are much obliged.
Very well. Meet on Monday, the 12th of May at 2:30 p.m. for the ruling.
Much obliged. Have a good evening.
Good evening.
Mapambano yanaendelea.